Welcome to Coffee Break, a podcast of Riverside County Child Support Services. My name is Nathan Hartel. I'm your host today, and I have a very special guest with me.
Hello, Elizabeth Lawrence, Chief Attorney here at Riverside County Child Support Services.
All right, thanks, Liz. It's good to have you with us today. We are back today with our coffee break, where we take a few minutes out of our day as child support professionals just to talk to the public, talk to our existing customers, folks who might want to know a little bit more about what we do. And today, we're going to focus in on the topic of child support enforcement and what does that mean. So if you're an existing customer of child support, you kind of know that there are certain actions that our department takes that you may not like, right? If we're being honest. So these are actions taken by the child support agency to help secure a payment on a court order. And Liz, these are legal court orders, right? These aren't things that we just made up.
Absolutely. We are not entitled to take action against anyone without a legal court order. And then those enforcement remedies, the ones we're going to be discussing here in a bit, they are required either by federal or state law.
Okay. And we're going to emphasize that kind of throughout our discussion this morning because we really don't want anyone to think that we are independently, either as caseworkers or as leaders in this organization, making choices and decisions about an individual's case or family situation and choosing to kind of go after somebody in a certain way. Most of these things just kind of happen. And the flexibility that we may have, there is some flexibility, but it's going to be in the conversation that we have with the customer where we kind of explore their circumstances.
Absolutely. And so important for everyone to understand that it is not our desire to pursue these enforcement remedies. What we would prefer to do is work with the customers to reach a remedy and bring that case to collection in everyone's best interest.
Right. And some of these are automated, which means our computer system just makes them happen without user intervention. So even though every one of our customers has a person, a caseworker that's assigned to their case, a lot of these actions are not being driven by that person. They're just happening through the system. Others are initiated by a person. Those are a little bit more few and far between. But I want to talk a little bit to our audience about, why do we need to discuss this and why are enforcement actions part of this? Really, it's in furtherance of our mission and our purpose as an agency. We are here to help ensure that children and families receive court-ordered financial and medical support. That's what we're here for. And in an ideal world, you wouldn't have to have certain things like an IRS tax intercept, a state of California franchise tax board tax intercept, and there's a bunch of other ones that we can kind of talk about those here as we go along. But unfortunately, we do live in a world where sometimes there is some extra motivation that might be needed to help secure those payments. So we have things like the tax intercepts, unemployment intercepts, some things that maybe come up less often, like a passport denial. And then there's things that every one of our customers pretty much experiences on a monthly basis, whether they know it or not, which is credit reporting. That's an enforcement action really too. Are there others, Liz, that you can think of that are just kind of a regular part of the child support program?
Absolutely. Another enforcement remedy is the pulling of driver's licenses. So we do suspend driver's licenses, actually all types of licenses, when the case is not in compliance. The income withholding order impacts all of our caseload, and I think that's important for individuals to understand that that is not a selective approach on any given case. State law does require that if we are enforcing an order in a case, that we send an income withholding order so that we are able to collect directly from an employer. And please know that employers cannot discriminate against the employee because we send the income withholding order. We also will issue property liens against any known property. If that property is sold, we can collect any past due arrears and bank levies, although there is a $3,500 exemption. So we would not be able to collect the first $3,500 on that bank account, or if there is a hardship. So very important for you to communicate with your caseworker if that happens to you.
And all of those are examples of automated enforcement actions. So that's a lot of them. And we're going to get into some of those in a little bit more detail in a moment. But that's important for our customers to realize that all those things are kind of happening behind the scenes. But are they happening to everybody? Well, ultimately, those are happening, some of them to everyone, even if you're paying regularly every single month, like the income withholding order. We'll talk about that again a little bit. We'll kind of use a little bit of maybe different language to break that down. Income withholding order is probably not words or a phrase that, most of our customers would, commonly use. But there are some actions that are discretionary. And those discretionary actions, and this is one of the reasons, Liz, why it's so good to have you on our episode today as an attorney, some of them have us going to court in the most challenging and the most difficult of situations where we are really trying to secure that court-ordered child support for a family who needs that money and it's not being paid. And there's a couple, like a civil contempt action, something called a judgment debtor exam. Can you explain a little bit about what those are? When do we use that discretion as an agency? And is that done all the time? Is that something most of our customers have to worry about?
Absolutely. So a civil contempt is probably the harshest approach that we can take in any given case on enforcing a case. And that is where we do file an action in court to have the individual answer to the court for why they are not following the court's order. And in a worst case scenario, the individual can face jail time. And because of that, we do not use that as a remedy very often. And at all times, it is reserved for those circumstances where the individual has the ability to pay, but is simply choosing not to pay their court-ordered amount. A judgment debtor exam is where we need additional information on perhaps where assets may be located, why the individual is not complying with the court order. So it may be a preliminary step where we bring the individual into court to answer questions on how we may be able to enforce against them.
And both of those things would require us to give ample notice, right, to customers. These aren't things that we do in secret.
Correct.
They're not things that a customer should be surprised by.
Not at all. By the time we get to this level, we have certainly done everything that we can to communicate, to try to enforce the automated and mandated actions that Nathan was discussing earlier. Those have all been in play. And now we are just confident that this individual is simply choosing to disregard the order.
Whether it's an action like that that's more select, or whether it's one of the automated ones, as a child support professional, and I don't know about you, but one of the things that concerns me when I think about our relationship with our customers is, what does that say about us as an agency in relationship to those customers? What does it say that we are taking those actions, have to take them, might choose to take them in connection to their role as a parent? You know, sometimes I think that through and I try to think about it from their perspective. And I know for me, first and foremost, it says that, you know, we have a goal of, you know, collecting child support and getting it to the families that need it. But it also says to me that we want to establish a rapport and a relationship with our customers so that when these things do come up, we can kind of engage with them. But I'm not sure if in your experience you've had, you know, conversations with customers or experiences in court where you kind of get a sense and a feel for how those enforcement actions feel and come across to customers rather than child support professionals. What do you think that is like?
Absolutely. I've had that experience over the many years. And I appreciate the way that the program is evolving to have a better understanding of how our discretionary actions impact the whole family. And I think for that reason, the civil contempt remedy is not used as often as it once was. And that's important because I think there's still a lot of misinformation out there where, being that we are an agency that once existed under the district attorney's office, there's still this view that we take a prosecutorial approach.
Right.
In Riverside County, what I can say, we are concerned with the impact, but we very much understand that there is a need for these families, you know, the children, to receive the collections on those orders, right? These orders are based on a determination and a consideration of the ability to pay by both parents. And in those few situations where we are able to identify where one individual is simply not willing to cooperate, then we need to have that stronger remedy. However, when they are brought into the process, if at any point they want to start cooperating, or if we're able to identify that perhaps we were mistaken with the information that we had, that is something that can be resolved without court action. Just critically important to give us the information and to participate with us.
Yeah, I think that's a good point, that ideally we do resolve things without court action. And even if we're in the middle of one of those, we're always open to talking to our customers because we do recognize that these things are sensitive. Mm-hmm. We are talking about families' money, You're talking about their children, actions we're taking. They're kind of, in the midst of all that. And we don't want our customers to feel like these are, punitive things that we're doing, without reason. There are unintended consequences of some of these enforcement actions. You mentioned, like the driver's license releases and things like that. So we'll talk about that in a moment. But I think it's important for our customers to understand that, we do have a mission and a job to do in collecting that child support. You mentioned it at the beginning. We'll mention it again now that these are legal court orders established through that process, not an arbitrary amount, come about by a caseworker, for example, who just, is making that up. So if you're a customer, then why should you really care about kind of the background of why we do enforcement actions and all that? I would say it's because most of our customers probably find themselves with some amount of past due child support that is owed. It's not every. Some customers are right on target and every single month they pay it. Let's kind of stop and focus in on that. If you are a customer who every month is paying their full child support obligation, of that list of enforcement actions that we talked about, which one hits that person?
Well, the income withholding order is still mandated by law. So even the individual who is absolutely compliant with all orders can expect to have their employer receive a wage garnishment. That is required by state law.
So can I call the department and in that situation and say, look, I have an arrangement, with the other parent. They really don't want that happening. Can't I just, kind of send you a check, you pass it on to them, or I give them the money and they turn around and tell you, we've got this great deal worked out. That's not a possibility?
Unfortunately, if the Department of Child Support Services is enforcing, that is the means by which we are required to enforce.
Okay.
Again, that is why it's important to understand that an employer cannot discriminate against you or receiving a wage garnishment. They are required to abide by it.
And there are some positive things too, right? You can turn this around and look at it as a positive in terms of bookkeeping.
Absolutely.
Records retention. If you are the person ordered to pay child support and it's coming out of your paycheck, regularly, you have your pay stub, you have a regular record that you can go to them to child support with or with the other parent and say, this is exactly what was taken, what was sent. What's the relationship and the responsibility of the employer in that case to work with the employee? Is there anything that the customer should be kind of watching out for related to that wage withholding and make sure that everything is going okay?
Well, certainly the employer has a responsibility to notify the employee that they have received a wage garnishment.
Okay.
They should be able to, they should receive a copy. And the employee wants to look at that and make sure it's accurate. If there's any concern with the amount that we are requesting to deduct, what should happen is you should contact the agency, so the Department of Child Support Services. Oftentimes, if the employee has concern, they believe that the best course of action is to take it up with their employer, but it really is an order against the employer, and the employer has no flexibility there.
Okay.
The only person or the only remedy at that point would be for the agency to issue a new wage garnishment.
Okay, that's good to know. And then staying on the topic of that customer who is just faithfully paying their full monthly support amount, how about all those other automated actions that we talked about, the license suspension, the intercepts? Are those things going to happen to that person?
So long as they remain compliant, they have no reason to be concerned about any of those enforcement actions.
Okay.
All of those kick in. They are mandated, but they are only mandated when someone falls into arrears.
Okay. So there's a trigger there that comes about when there's a past due child support amount, and then some of these other things start happening.
Correct.
So let's talk about intercepts a little bit. The most common one would be tax intercepts. So that's a situation where a customer has a past due child support balance and they file their taxes. If you're not filing, this isn't gonna happen. But if you're filing your taxes and you have a refund due, how does child support enter into that equation? And how does the IRS or franchise tax board know to send us that money instead of giving it back to the customer?
Well, again, by law, a state and federal law, we are required to report when someone falls past due. And their system aligns with our system. When they receive the report of which individuals are past due, they are required to withhold any refund that would otherwise go to the customer. So that refund will instead be redirected to the child support agency that has reported them past due, up to the amount that is past due.
Okay. And the word intercept means that this is just happening kind of behind the scenes.
Correct.
This is not a request from us to our customer to say, hey, if you have a refund, coming to you from your federal taxes, please send it to us. This is just going to happen.
Correct.
And same thing with unemployment benefits. So if someone is receiving unemployment benefits, is that intercepted?
It is.
Okay.
Up to 25% of their
25%.
unemployment.
Yep.
Correct.
Okay. So that's something for people to be aware of. If you're out of a job but you're receiving unemployment, you can look at all these things and find the positive side to it. You can find the silver lining for your child support case and for what you owe. You may have wanted to get that tax refund back, but this is money that's going to go to pay down your balance, which will hopefully, in the end, get it paid off, and you'll have less enforcement actions. And the same thing with the unemployment benefits. If you're receiving unemployment benefits, I would say the fact that some of that is being intercepted is maybe secondary to a more important thing that you should be thinking about, which is probably to make sure that your court order is correct.
Yes, that's such an important point, Nathan. We definitely want to do the right thing. We want to work with you at all times. And we are required to enforce those valid court orders, but those orders are modifiable at any point in time when there is a change in circumstance. So it is in your best interest when there's a change to your income or even a significant change to visitation. It is worth calling us to see if that's going to make an impact to the total dollar amount that you owe. Again, a reminder, even if you have been paying on time, if there is a change in circumstance and you lose the ability to pay in full, some of these automated, enforcement actions will kick in, even though your circumstances are challenging. So best to communicate with us earlier.
Absolutely. I think one of the frustrating things for even a lot of child support professionals is the law in California that interest is going to be charged on past due child support balances. I'm sure customers would prefer that not be the case. And let's be honest, child support professionals probably would rather that not be the case too. It often feels like people are kind of being set up to have an even harder time in resolving that. So why is that done? Can you just speak a little bit to the fact that that is a reality and why that's there?
Sure. So at the base, a child support order is a money judgment, and it is no different than other money judgments of other types of cases. You can imagine if you sued someone from you have a car accident, you sue someone, you get a judgment on that case. Both of these money judgments are entitled to interest in California if they are not paid timely. And it is the same 10% per year that is charged in California, and that is written into state code. And I agree with you, Nathan, working in this area, it is not something that I have ever been a fan of, right? I think it does burden families unnecessarily. However, again, it is one of those areas that we're just bound by it. I think there's also a lot of confusion on interest. Individuals sometimes believe that that is an amount that is kept and collected exclusively as money to the agency or to reimburse the government. It is just collected as additional child support payable wherever that's due.
That's really important. I'm glad you mentioned that. As is always the case, anything that is paid, the department does not keep that. That does not go to pay salaries. It doesn't go to fund, rent on buildings, nothing like that at all. So where does interest get changed? Where does that law find, a place of discussion and the possibility of it being changed? That at the California Department of Child Support Services in Sacramento, where they would have some discussions with legislature? Is that a federal thing? Because it's not the county. You're not going to have a customer contacting us at Riverside Child Support and saying, hey, can't you do something about that unfair 10% child support?
Correct.
Interest?
And the law presently, the 10%, that is state law. If there is any interest in having discussions, it would be with the state legislature. Okay. Unfortunately, the county, certainly the agency has no authority.
Yeah. And that's one that comes up a lot. And that's why I brought that up. Just want to make sure customers know we really can't engage in a conversation to change that. That's not our place to do that. Let's talk about one of the most common ones, and that's the driver's licenses. Really any professional license. I mean, we're talking fishing licenses that might be considered related to hobbies, but fishing is not always just a hobby for someone. That could be their employment and their livelihood. Driver's license is just a regular day-to-day one. And you definitely have people who think this is just so unfair. How can you possibly do this? So how does Riverside Child Support balance that? First thing first, you've got to contact us. If you're a customer, you're going to get noticed by the agency that has licensed you.
Correct.
Is that right? So if it's a driver's license from the DMV, if it's maybe Department of Consumer Affairs for a variety of other licenses, but it's not going to be child support in Riverside sending you something in the mail saying, hey, your license has been suspended. So they have to be paying attention to what's going on. You got to get your mail, you got to open things and see what's happening. And then first step is to call us, or is it to call the agency that sent them the letter?
Once you have received the notice from the agency, you really want to call us, because while we're not the licensing agency that ultimately suspended the license, they're doing so based on us notifying them that you are not compliant with your child support order. So if there is some confusion, or if you are able to make payment and come into compliance, or if we can negotiate an agreement, all of that is going to happen with you communicating with us. So first step I would say is contact us. Then we can communicate with the licensing agency if there's going to be a change as a result of the discussions that you have with us. What's important, though, is understanding, since we aren't the licensing agency, even if we enter into an agreement to have them release the license, you then need to contact the licensing agency to see what their steps are to ensure that your licenses are in fact reinstated.
Okay. And a lot of times when customers contact us, basically it's a conversation, but it's not always a call, a request to release it, and just an automatic yes. So there may be an agreement that we need to reach with the customer where we say, hey, this happened because you're not paying. We need to help get you back on track. So we're willing to release it. The driver's license, using that as an example, sometimes we'll do a temporary release, and they'll have that for a certain period of time in exchange for them promising to start making their monthly child support payments. If an arrangement like that is made and then it's broken, what happens after that? Just sticking with the driver's license, can the department then kind of take back the release that was done?
Correct. Not only can the department take it back, but they must suspend the license again, or request that the license be suspended, because this is a mandated enforcement remedy. So part of the negotiating with you on the front end is not because we have discretion fully in this area. It's that we can try to get you to a place to where your case is now in compliance. Right. Once that happens, then it's appropriate to reinstate your license. But if those terms are not kept, then we now find ourselves in that mandated position again, where we have to report to the licensing agencies that you are no longer in compliance.
Right. And we try to be very sensitive to the fact that, again, employment, livelihood can be connected to some of these licenses. So it's in our best interest, as well as the customer, to try to find an arrangement that we can make and get that license back. But to your point, it's not I contacted child support, they said they would release it, I'm done.
Correct.
I never have to engage in this conversation or pay attention to this again. You don't want to just revert back to maybe a status of non-paying. You want to keep your arrangement, keep the agreement that you made. Driver's license, truck driving jobs, just commuting back and forth to work, they're really, really important. We even have special events sometimes throughout the year. August is Child Support Awareness Month, and we had a particular day where if customers would show up to any one of our 3 offices on that day and just engage with us, just come in, meet with a child support professional, say, hey, I have a case. I want to kind of update my information, tell you where I'm at. I know my license is suspended. We offered on that special day to just basically release it with no money down. There are other days, again in August, where we kind of do it for $5. And even throughout the year, we have flexibility. So while our job is, again, to collect that child support and we want to get as much as we can for the family, we just want you to come in and talk to us. So that's been my experience. Any other thoughts or experiences related to license releases that might be helpful for our listeners?
I think important to know that while you should always contact us first, if for whatever reason we are not able to reach an agreement with you, we simply do not feel that we have come to a place to where we can let the licensing agency know, go ahead and reinstate your license, but you still feel like you want the opportunity to be heard, you can always file an action with the court and ask them to review and consider whether or not your license should be reinstated. That is an option for you if you cannot first resolve that with the Department of Child Support Services. But contacting us should always be your first step.
Great. And I appreciate you bringing that up. All right. So we're going to move on to, I think, our last 2 enforcement actions that we're going to talk about. One is property liens. What does that mean? Again, maybe a phrase, words that a lot of people may not be familiar with, and passport denial. So let's start with the passport one. So how does a customer come to be in a situation where they can't travel and they find out that their passport really is not doing them any good here because they have a past due child support balance?
Well, first, important to understand that the issuing agency for passports is a federal agency. This is now bigger than the state of California.
Okay.
So federal law requires that child support agencies report individuals who are not in compliance with their child support orders. At the time of you requesting for a passport, they are going to check those lists. And if you are not in compliance with a passport, I think if you owe more than $2,500 at the time that they check, you will be denied the passport. And the law requires that amount to be paid in full before you qualify for that passport to be issued. And this applies at the initial issuance of a passport and at the renewal stage as well.
Okay.
So it's important because it's a little bit different than the driver's license. The driver's license, we can reach an agreement with a small payment. Nathan mentioned as much as $5 just to show that you're cooperating. With a passport, there is zero flexibility. It is federally mandated and federally controlled. So the agency really doesn't have discretion at all. And the amount that must be paid to get out from under it as soon as you owe more than $2,500 is the total amount that is due and owing. You would be required to bring your account balance to zero.
Okay. So that one's a little bit different, and that's a little more extreme than some of them. It's also one that finds, I would say, a fewer number of our customers impacted by it.
Correct.
Okay. Now let's talk about property liens. So when is a lien placed on someone's property? So does that mean that if you are any child support customer who happens to own a home, are you going to find yourself potentially with a lien placed on the property against you? When does that come up? When you sell your home, when you're refinancing it? You mentioned with passports that there's a process at issuance of a new one and renewal of a passport. So is there kind of a similar thing with property? If you're going to look to buy a home, refinance a home, sell a home, someone is checking?
Absolutely. So once the order is entered, the agency will identify the county in which the obligor resides, and also perhaps any other counties where we have reason to believe that property may be owned. And we will file what's called an abstract of support judgment in that county. That is a record that any title company will be able to locate at the time that the property is being sold or refinanced. In that process, as soon as they locate the abstract for support judgment, the title company is required to contact the Department of Child Support Services and ensure that with the proceeds of the sale of the property, that the child support amount that is due and owing is paid, or at least paid to an amount that is satisfactory.
Okay. And again, I would imagine having a conversation with child support and with the title company, that's all key and foundational to that entire
very
thing.
important, because this can slow down the transactions, the real property transactions. And sometimes people are selling properties, they have those strict dates and deadlines, and it is never our intention to interfere with individuals relocating or anything of the sort. We don't want deals to fall through. So first step is please contact us.
Absolutely. So there's a few themes here in our conversation, right? So if we were to kind of summarize and wrap this up, I would say customers, number one, should know, contact us right away. And they should know that we are here to help them. We're not here to make this more difficult than it has to be. They should understand that some of these actions are automated. Very few of them are discretionary, and those that are discretionary, we're really exercising those rights in limited cases, like the civil contempt or the judgment debtor exam, in very small numbers usually, to help us deal with difficult situations. But customers should recognize that we are aware of the sensitive nature of these things, that we want to help them, and we don't want it to be overwhelming. You know, it's a lot of things here that could make a customer feel defeated, afraid, worried. And the worst thing that can happen, in my experience, is to ignore letters from child support because you are worried, you are afraid, you think that if you contact us, things can only get worse. I can promise you from, over 20 years of experience in the program that contacting us pretty much is only going to make things better.
Yeah, I agree.
Even if it's just getting information and understanding processes better, I can't promise that the outcome is always going to be to every customer's liking, but I don't think I've ever seen it be a bad thing for a customer to get in touch with us.
And I think important for anyone listening who hasn't contacted us in a while and shares some of those concerns, I understand completely. I think we can understand that this can be an intimidating process, but please know that it's never too late. It's not listening to this and thinking, oh, I should have contacted them if I had only known this back then. Today is a good day. Contact us today and we will do what we can to help get you back on track.
That's great. Great way to end it. It's never too late. Today is a good day to contact us. Please do that. Liz, I want to thank you for spending a few minutes with me and with our audience talking about child support today. My coffee cup is just about empty, which signals the end of our episode today. So let me share a little bit of information about how you can get in touch with us. You can go to our website at RivCoDCSS.com. You can also call us at 866-901-3212. And you can email us at RivCoDCSS@rivco.org. Please come in person if that is your preference. We do have virtual appointments available, but we have offices in Riverside, Blythe, and Indio. We're here to help you, and we are also open one Saturday per month to help meet our customers' needs. So please take advantage of those opportunities. It was a pleasure speaking with you, and we'll talk to you next time.